Welcome to the Learning Studio, where we decode the laws that solve real-world problems and shape a more just and peaceful society. In today's episode of our law series, we step into the world of negotiation tables, private hearings, and out-of-court settlements. Welcome to the realm of dispute resolution and arbitration. Check out the full law series playlist using the link in the video description below to explore more essential legal topics. What if two global companies have a billion-dollar disagreement but don't want a public trial? What happens when countries clash over trade or investment but want a peaceful solution? Can people resolve personal or business conflicts without ever going to court? The answer lies in dispute resolution and arbitration, a legal path that avoids the courtroom and focuses on efficiency, privacy, and fairness. What is dispute resolution and arbitration? Dispute resolution refers to the various legal methods used to settle conflicts without full-scale litigation. It includes negotiation, direct discussion between parties; mediation, a neutral third party helps parties reach a voluntary agreement; conciliation, similar to mediation but often more advisory; arbitration, a private process where a neutral arbitrator delivers a legally binding decision. Arbitration in particular has become the go-to method in international business, trade, investment, sports, and construction, where speed, confidentiality, and expertise are crucial. Historical and legal context. Dispute resolution is as old as human society. Ancient tribes, kingdoms, and religious institutions all had ways of resolving conflicts peacefully. Modern arbitration gained global recognition through the Geneva Protocol, 1923, the New York Convention, 1958, which ensures international arbitral awards are enforceable in over 170 countries. Institutions like the International Chamber of Commerce, ICC, London Court of International Arbitration, LCIA, and ICED for investment disputes. Many countries now encourage alternative dispute resolution, ADR, in civil, commercial, family, and labor matters to reduce the burden on courts and promote harmony. Famous case study: Amazon v. Future Group, India. In a high-profile dispute over a multi-billion-dollar merger, Amazon invoked an arbitration clause in a contract with Future Group, preventing it from selling its assets to a competitor. The case went to Singapore International Arbitration Center and triggered complex legal battles in both India and international forums. This case showcased how arbitration can influence major corporate strategies, even across borders, and reinforced the legal power of arbitration clauses in contracts. Why dispute resolution matters today. In a world where litigation is often expensive, time-consuming, and public, alternative resolution methods offer privacy and speed, specialized expertise, cross-border enforceability, reduced hostility, and better business continuity. Governments, companies, and individuals are increasingly relying on ADR to resolve issues more constructively. What's next? If you're interested in commercial law, diplomacy, corporate strategy, or international relations, dispute resolution and arbitration is a field full of global relevance and intellectual challenge. In the next episodes, we'll explore space law, legal systems around the world, and comparative law, offering you deeper insights into how laws operate across borders and beyond. You're watching The Learning Studio, and this is the Law Series, where justice isn't always served in courtrooms, but through dialogue, dignity, and design.